The concept of locus standi is not applicable to criminal law. So anybody who has the information related to the commission of an offense or particularly cognizable offense, that person can always approach the concerned police officer in charge, and he can always give that information to the police. It is not prerogative on the part of the person whether he himself is affected by that offense or not. It is not mandatory that he should be the victim of that offense. The only thing is he must have information, direct or indirect information, related to that offense, that somebody has committed the offense. And whenever you call the police on mobile and you tell the police officer that such and such offense is being committed, you don't disclose your identity, you don't tell the police the place at which this information, offense has been committed, that in that situation the police might not take any action. So whenever people call police control room at 112 or number 100, they think that information that is conveyed to the police control room is the FIR. It is not. Or whenever you are in a market or at a public place or something happens to you, or you see offense is being committed or an offense has been committed against somebody in your presence, and you call you see any constable or head constable, and you give that information to that constable, that is again not FIR, because FIR is the first information that is given to the police in charge of a police station. So in Delhi, it is the SHO, in UP, it is the station officer. So in every state, there is one police officer in charge of a police station. So it is always advisable whenever you call the police control room at 112 or number 100, after that, you should reach the concerned police station, give your information in writing. If you can't write it, doesn't matter. You can always tell it to the concerned police officer, the investigating officer or the SHO. Give that information orally, and it is his duty to write it down and then read it over to you to tell you that this is what I have written. And after that, the statement has to be signed by you, because whenever the police officer asks you to sign this information, if you don't sign it, there are basically two implications. First, the court will always see this information with a little bit of doubt. Second, if you don't sign it and the investigating officers ask you, okay, you should sign it, in that situation, the not signing may make you liable under section 180 IPC, and action can be taken against you. The another important aspect of the FIR is whenever you give any information to the police officer or any public officer, and you give a false statement or false information, then at the end of investigation, action under section 182 IPC may be taken against you. These two provisions have been incorporated in our criminal law just to make the information truthful. But personally, what I have seen is I have not seen many cases wherein section 182 has been invoked by police officers. What they do is, if the FIR is registered and at the end of the investigation it is found to be false, then they file the closure report, that is called the final report. Closure report that this offense is not committed by this person as alleged by the complainant. But in none of the cases, in most of the cases, they don't take any action against the complainant or the informant for supplying the false information, which should be the prerogative. And just because of this lacuna, this inaction at the end, part of the police, there are so many false cases of 376, dowry, and other cases also.